The most powerful law enforcement officer in the United States did not send a subpoena. He did not schedule a press conference. He picked up a phone at 2 in the morning and called a defense attorney in New York City because he was afraid of one man in Harlem. By the early 1950s, the United States Department of Justice had spent the better part of a decade building legal infrastructure designed to dismantle organized crime in American cities. The Kefauver Committee hearings of 1950 and 1951 had placed organized crime on national television for the first time, exposing the machinery of illegal gambling, extortion, and political corruption to a public audience that had previously only read about it in tabloids. The political pressure generated by those hearings did not disappear when the cameras left. It transferred directly onto the desks of federal prosecutors in every major American city. New York was the center of that pressure. The 5 Italian-American crime families that operated across the 5 boroughs were the primary targets of federal attention, and the DOJ devoted significant resources to building cases against their leadership. But Harlem presented a different problem, one that the DOJ's existing framework was not designed to address cleanly. Ellsworth Raymond Johnson, known in Harlem and in federal files alike as Bumpy Johnson, operated the numbers racket in Harlem with a degree of organizational discipline that federal investigators found difficult to penetrate. The numbers operation was not a simple gambling enterprise. It was a financial system, one that moved money through Harlem's economy in ways that touched laundromats, barbershops, restaurants, and the daily transactions of ordinary working people who had no other access to informal credit or economic participation. Bumpy Johnson understood this. He had built his operation on that understanding. What made Bumpy a federal target was not simply the scale of the numbers operation, though the scale was considerable. It was his refusal to be absorbed. The Genovese crime family, which had attempted to assert control over Harlem's rackets since the 1930s, had never successfully subordinated Bumpy Johnson's operation to their structure. He had negotiated, fought, and maneuvered his way into an arrangement that gave the Genovese family a percentage while preserving his operational independence. That independence was, from the DOJ's perspective, both the problem and the complication. Federal prosecutors building cases against the Italian families could construct a legal theory around hierarchy: boss, underboss, capo, soldier. The Genovese structure had legal vulnerabilities precisely because it was a structure. Bumpy's operation was harder to prosecute under the same framework because Bumpy himself was not embedded in that hierarchy. He was adjacent to it. The legal theory required to prosecute him was different, and building it required different evidence. Through the early 1950s, federal investigators in New York assembled a case file on Bumpy Johnson that drew on surveillance, informant testimony, and financial records. Associates were pressured. People connected to the numbers operation in Harlem were approached by federal agents and offered deals in exchange for cooperation. Some of those approaches worked, others did not. Bumpy's network inside Harlem was not built on fear alone. It was built on a set of mutual obligations that the federal government's offer of leniency was not always capable of overriding. By the mid-1950s, the federal case against Bumpy Johnson was advanced enough to move toward indictment. The evidence was not airtight, but federal prosecutors believed it was sufficient. What they had not is fully calculated was the position of the man at the top of the DOJ and the calculations he was making that had nothing to do with legal sufficiency. The Attorney General of the United States in this period was a man with significant political ambitions that extended well beyond his current office. Washington in the 1950s operated on the assumption that the Department of Justice was both a law enforcement institution and a political instrument, and the two functions were not always separable. The AG understood this. He had built his career on understanding it. The pressure to prosecute organized crime figures in New York was real and came from multiple directions simultaneously. Congressional committees wanted visible results. The press wanted indictments. The White House wanted the appearance of action against criminal networks that had become a domestic political liability. Bumpy Johnson's name appeared in federal case files, in congressional records, and occasionally in newspapers, enough to make him a recognizable target and enough to make his prosecution a political asset if it succeeded. The problem was the calculation of what happened if it did not. Inside the DOJ, senior officials reviewing the Bumpy Johnson case file identified a set of vulnerabilities that made a public trial dangerous in ways that went beyond the question of conviction. Several of the federal informants whose testimony formed the backbone of the case were embedded not only in Harlem's criminal network, but in the broader political machinery of New York City. Their identities, if exposed through the discovery process that a public trial would require, would unravel relationships between federal law enforcement and city officials that the DOJ had spent years cultivating. Some of those relationships were legitimate law enforcement partnerships, others were not. The distinction mattered less than the exposure. Beyond the informant problem, the numbers operation in Harlem had financial connections to political figures in New York City, whose names the DOJ did not want attached to a public proceeding. Campaign contributions, property transactions, and the movement of money through legitimate businesses created a paper trail that defense attorneys, if given access to the full financial record, could use to construct a narrative that was damaging not to Bumpy Johnson, but to the institutions prosecuting him. The AG reviewed this picture and arrived at a conclusion that was not written into any memorandum. A conviction was possible, but not certain. An acquittal was possible, and given the evidence vulnerabilities, more likely than his prosecutors were willing to admit publicly. An acquittal in a high-profile federal case against a figure like Bumpy Johnson, a black crime boss who had publicly positioned himself as a protector of Harlem against both organized crime and government neglect, would be a political disaster of the first order. The press coverage would not focus on legal technicalities. It would focus on the government's failure. The AG wanted the problem to disappear. He wanted Bumpy Johnson removed from New York without the government having to remove him through a process that could go wrong in public. The calculation was not about justice. It was about exposure management. And the decision he made to address it, picking up a phone at 2 in the morning, was itself a serious miscalculation. Bumpy Johnson's attorney at this time was a man who had navigated the intersection of Harlem's political world and its criminal defense bar for years. He had represented clients across a range of federal and state cases, and he understood, as any attorney practicing in that environment understood, that the line between official legal process and informal resure was rarely as clear in practice as it appeared in theory. He had received calls from prosecutors before. He had not received a call like this. 1. The call came after midnight. The voice on the other end identified itself. The message that followed was direct and required no interpretation. The federal case against Bumpy Johnson would not proceed to indictment. No charges would be filed. No arrest would be made. The condition attached to that outcome was equally direct. Bumpy Johnson was to leave New York City by Friday, permanently. He could go anywhere. He simply could not remain in New York. The attorney listened. He did not agree to anything. He did not decline anything. He said he would deliver the message. The call ended. What the Attorney General had constructed in his own mind when he made that call was a transaction, one that he believed a rational actor would accept. Bumpy Johnson was facing the possibility of federal prosecution. Federal prosecution, even if it failed, meant years of legal exposure, financial cost, disruption to his operation, and the constant pressure of the government's attention. The offer on the table eliminated all of that. Walk away from Harlem and walk away clean. The AG's calculation rested on an assumption that proved to be incorrect. He assumed that Bumpy Johnson's relationship to Harlem was instrumental, that Harlem was the location of his business, and that a man in Bumpy's position would relocate his business if the alternative was prosecution. It was the kind of assumption that made sense when applied to the Italian crime figures the DOJ more routinely dealt with. Men whose organizational structures could, in theory, be transplanted from one city to another. Bumpy Johnson was not that kind of operator. His relationship to Harlem was not geographic convenience. It was identity. He had grown up in that neighborhood. He had fought for control of it across decades of violence and negotiation. He had buried people there and been mourned for people buried there. His standing in Harlem as a protector, as a figure who mediated between the street and the political world, as a man who fed people during hard winters and settled disputes that the police would not touch, was not transferable. It was specific to that place and to the people in it. The attorney delivered the message. He laid it out exactly as it had been communicated, without embellishment and without his own interpretation. Bumpy heard it. He did not respond immediately. He sat with it. When he spoke, he did not express anger. He asked one question: "How many people do you think know about this call?" The Attorney General had made his call from a position of assumed superiority. He controlled the legal machinery. He controlled, as far as he understood it, the terms of the arrangement. What he did not control, and what he appears not to have known he did not control, was the information environment in which Bumpy Johnson had been operating for years. Bumpy's intelligence network was not a formalized structure with identifiable members. It was a set of relationships built over decades with people who occupied positions at every level of New York City's institutional life: courthouse clerks, police department dispatchers, city hall staff, low-level federal employees whose jobs brought them into contact with case files, scheduling records, and internal communications. These were not paid informants in any formal sense. They were people who had, at various points, received assistance from Bumpy Johnson: financial help during hard times, intervention in situations that required someone with Bumpy's particular kind of influence, or simply the kind of loyalty that developed between people who had grown up in the same neighborhood and understood each other's circumstances. Through this network, Bumpy had received information about the federal case building against him that went beyond what his attorney had been given through formal legal channels. He knew which witnesses had been approached. He knew, in general terms, what those witnesses had been offered and what some of them had said. He knew that the case had internal weaknesses that federal prosecutors had not resolved. And he knew that there were people inside the DOJ's New York operation who were uncomfortable with the direction the case was taking. He also knew something more specific. The 2 a.m. phone call from the Attorney General to his defense attorney was not a legal action. It was not part of any authorized prosecutorial process. It was a private communication made by a government official attempting to coerce a private citizen into leaving a city without legal basis for demanding it. The AG had stepped outside the framework of the law he was employed to enforce, and in doing so, he had created a vulnerability for himself that was considerably more serious than anything the federal case against Bumpy Johnson contained. Bumpy understood leverage. He had operated in an environment where leverage, the controlled use of information that one party held and another party feared, was the primary currency of power. He did not need the federal case to go away through legal argument. He needed the person driving the federal case to understand that the cost of continuing had become personal. He had the information to make that point. He had acquired it not through any dramatic intelligence operation, but through the ordinary accumulation of knowledge that came from decades of paying attention to the people around him and the world they moved through. The AG's personal life, his family's movements, the physical locations. He and the people connected to him occupied on a regular basis. This was information that existed in the world. Bumpy had it. The AG did not know he had it. What Bumpy constructed in response to the 2 a.m. call was not a threat in any form that could be prosecuted. It was a demonstration that the information environment the AG believed he controlled was not, in fact, controlled. Bumpy Johnson did not respond to the Attorney General through his lawyer. He did not send a verbal message. He did not make a phone call. He sent an envelope. The envelope was sealed. It was delivered by courier to the Attorney General's office in a manner that ensured it reached the AG directly, without passing through the hands of staff members who would log it, read it, or retain copies. The delivery itself was a message that Bumpy's reach extended to the physical space of a federal office in a way that the AG had not anticipated. The contents of the envelope were never entered into any official record. No legal proceeding ever produced the envelope as evidence. No sworn testimony from anyone who was present when the AG opened it has ever been made public. What is known about the contents comes from accounts given by people close to Bumpy Johnson in the years and decades that followed. Accounts that are consistent with each other in their essential description, even where they differ in detail. Inside the envelope were photographs, not documents, not written threats, not legal filings or copies of incriminating records. Photographs. The photographs showed the Attorney General's family home, the exterior of the building, taken from a street-level position that made clear the photographer had simply stood on a public sidewalk and pointed a camera. They showed his wife leaving a building, not a government building, a private building, in the course of her ordinary day. Routine. They showed his children at school, going about the ordinary movements of children whose father happened to be the most powerful law enforcement officer in the United States. There was no note in the envelope, no written demand, no explicit statement of what the photographs meant or what Bumpy Johnson intended. There did not need to be. The photographs communicated everything that needed to be communicated, without a single word that could be read aloud in a courtroom or quoted in a newspaper. The AG's family existed in the world. They could be seen by anyone who chose to look. Bumpy Johnson had chosen to look. And now the AG knew it. The AG opened the envelope alone. No staff member was present. No aide witnessed his reaction. What is recorded is what happened in the days that followed. Within 48 hours of the envelope's delivery, internal communications within the DOJ's New York office began to reflect a change in direction regarding the Bumpy Johnson case. Meetings that had been scheduled were quietly canceled. A prosecutor who had been leading the case preparation was reassigned to an unrelated matter. No formal memo announced a change in case status. The case did not officially close. It simply stopped moving. The machinery of federal prosecution, which had been building toward Bumpy Johnson for years, went still. The silence that followed the envelope's delivery was not the silence of resolution. It was the silence of a decision that could not be explained publicly by the person who had made it. The federal case against Bumpy Johnson did not produce a dismissal order. It produced nothing. It simply ceased to generate activity. No grand jury was convened. No indictment was issued. No arrest was made. The witnesses who had been cultivated over years of investigative work were not called to testify. The financial records that federal investigators had assembled were not presented to any court. The case existed in the files of the DOJ's New York office as an open matter, but open matters that generate no activity are in practical terms closed. Bumpy Johnson's attorney was never contacted again by the AG's office. No follow-up communication arrived. No revised timeline was proposed. The call that had come at 2 in the morning was never referenced again by anyone in an official capacity. From the government side, it was as though the call had not happened. This silence was itself significant. A federal case of the size and duration that had been built against Bumpy Johnson did not simply stop without explanation. Prosecutors who had spent years on a case did not accept reassignment without understanding why. People within the DOJ's New York office knew that something had changed and that the change had not come through normal channels. The explanation that circulated internally that the case had evidentiary problems that made prosecution inadvisable was accepted because it was available and because the alternative explanation required people to ask questions that nobody in that office wanted to ask. In Harlem, the information moved differently. There were no press releases, No court records entered the public domain. No attorney gave a statement to a reporter. But Harlem's information infrastructure, the barber shops, the restaurants, the numbers runners and street-level operators who moved through the neighborhood every day, processed what had happened with considerable accuracy. People who needed to know understood that the federal case had stopped. They understood that it had stopped because Bumpy Johnson had responded to the government's pressure in a way that the government had not anticipated and was not equipped to counter. Bumpy himself said nothing about it publicly. He returned to his regular R locations. In Harlem, the restaurants he frequented, the corners where he was known, the community events where his presence was expected. Friday arrived, the deadline the Attorney General had set for him to leave New York. Bumpy was in Harlem. He was seen by people who knew him. He was not leaving. He had never considered leaving, and the government that had told him to leave had stopped saying anything at all. 22 days after the envelope was delivered to the Attorney General's office, the AG announced his resignation from office. The announcement was made through a formal statement that attributed the decision to personal considerations, specifically his health and a desire to return to private legal practice after years of public service. The language of the statement was conventional. It expressed gratitude for the opportunity to serve, acknowledged the work of the department's staff, and offered no specifics about the circumstances driving the decision. Washington received the resignation without public skepticism. Resignations from cabinet-level positions for stated personal reasons were not uncommon in this period, and the press coverage that followed the AG's announcement treated it as a routine transition. No journalist in any publication of record connected the resignation to the Bumpy Johnson matter. No congressional inquiry was opened. No successor was asked in confirmation hearings about the circumstances of the departure. The official record of the AG's resignation contains no reference to Harlem, no reference to an envelope, no reference to a phone call made at 2 in the morning to a defense attorney in New York City. The departure is documented in the historical record as a voluntary transition made for personal reasons by a public official at a point of his choosing. The timing, 22 days, was noted by people who were close to both sides of the story. Bumpy's associates understood what the timing meant. People within the DOJ who had been present for the internal movement of the Bumpy Johnson case and who had watched its sudden deceleration following the envelope's delivery understood what the timing suggested. But understanding and documenting are different things. None of what those people understood entered the public record as connected. The AG left Washington. He returned to private legal practice. He did not become a prominent figure in subsequent political events. His career in government ended with that resignation, and the public explanation for the ending was the one he had provided: personal health, private practice, the ordinary rhythms of public service concluded. The historical record accepted that explanation because no competing account was ever formally advanced. In Harlem, no explanation was necessary. The timeline was the explanation. The man who had called at 2 a.m. and set a Friday deadline was gone from office before the month was out. Bumpy Johnson was still in Harlem. The 2 a.m. phone call and the envelope that answered it reveal something specific about the nature of power in 1950s America that does not appear clearly in the official historical record of the period. The Attorney General of the United States, in making that call, had stepped outside the legal authority his office conferred. There was no statute, no precedent, no authorized prosecutorial procedure under which a cabinet-level official could direct a defense attorney to instruct his client to leave a city. The call was not a legal action. It was a private communication by a government official attempting to produce an outcome, Bumpy Johnson's departure from New York, that the legal system could not guarantee and might not produce. In making that call, the AG had exposed himself to exactly the kind of vulnerability he was trying to avoid. He had created a record, not a written one, but a real one, held in the memory of the defense attorney who received it, and in the knowledge of the small number of people who learned of it afterward. That documented an act of official misconduct. If that record were ever produced in a context where it could be examined, the consequences for the AG would be severe, not professionally inconvenient. Severe. Bumpy's response did not use the law to counter this. He did not direct his attorney to file a complaint with the Bar Association or approach a judge. He used information. The photographs in the envelope were not illegal to possess. They were not obtained through any process that constituted a crime. They were the product of observation, of paying attention to the movements of a public official's family in the course of their ordinary lives. What made them powerful was not their content. It was their existence in Bumpy Johnson's hands. This is the distinction that the AG had failed to account for. He had assumed that his institutional position gave him an information advantage over a man who operated outside institutions. He was wrong. Bumpy Johnson had spent decades building an intelligence capacity that was not dependent on warrants, subpoenas, or official channels. It was dependent on relationships, on the trust of people who moved through New York City's institutional spaces and who chose, for their own reasons, to share what they observed with a man in Harlem who had earned that trust. The federal government's approach to organized crime in this period rested on the assumption that the state's monopoly on legitimate information gathering gave it a structural advantage over criminal operators. Bumpy Johnson's career demonstrated the limits of that assumption with a consistency that the DOJ's case files record without quite acne, owl-edging. The collapse of the federal case against Bumpy Johnson did not produce a public moment. There was no announcement, no press conference, no legal victory that Bumpy's attorney could describe to journalists. The case had not been won in court. It had been rendered inert through a process that could not be publicly described by anyone involved in it. What changed in Harlem was not Bumpy Johnson's legal status. He remained, on paper, a man whose federal case file was technically open. What changed was the practical reality of his position. The federal pressure that had been building against his operation for years had stopped. The witnesses who had been cultivated to testify against him were no longer being managed by an active prosecution. The financial scrutiny that had accompanied the case preparation had ceased to generate activity. For Harlem, the significance of this was understood at the level of daily life. Bumpy Johnson's operation had continued through the period of federal pressure, but that pressure had created friction in the conduct of business, in the confidence of people connected to the operation, in the general atmosphere of the neighborhood, which absorbed the awareness that federal attention was concentrated on one of its most prominent figures. When that pressure lifted, the friction lifted with it. Bumpy's standing in the community was, if anything, reinforced by the episode, not because its details were publicly known, but because its outcome was visible. The federal government had moved against him. He was still there. The people who had expected his arrest or departure had been wrong. In a neighborhood where the relationship between institutions and residents was defined largely by the institutional exercise of power over ordinary people's lives, a man who had absorbed the full attention of the federal government and remained unmoved occupied a particular position in the community's estimation. The oral history of Harlem, the accounts that passed between people who were present, that were told to children and grandchildren, that circulated in the spaces where Harlem's institutional memory was maintained, carried the story of the envelope and the Friday deadline that was ignored. The story lost specificity over time, as oral histories do. Names became approximate, timelines compressed or expanded. But the essential architecture of the story, the government's ultimatum, the envelope, the resignation, the man still standing in Harlem, survived in the telling with a fidelity to its central meaning that printed historical records rarely achieve. Politicians who needed Harlem's support understood what the story meant. Clergy who navigated the relationship between their congregations and the street-level economy that partially sustained them understood it. People who had no direct connection to Bumpy Johnson's operation, but who lived in the neighborhood he had shaped for decades, understood it. The story was not about crime. It was about the distribution of power in a city where official power and actual power did not always coincide. The episode of the 2 a.m. call and the envelope was not an isolated event in Bumpy Johnson's relationship with the federal government. It was one instance in a pattern that extended across the entirety of his career, a pattern in which official attempts to remove or neutralize him produced outcomes that were consistently less definitive than the government's resources and authority would have predicted. Federal law enforcement made multiple serious attempts to build prosecutable cases against Bumpy Johnson over the course of several decades. He was arrested. He served time in federal prison. He returned to Harlem after each period of incarceration and resumed his position in the neighborhood with a consistency that federal prosecutors found difficult to explain through the frameworks they had available for understanding criminal operations. The explanation that Bumpy's longevity demands is not primarily about corruption, though corruption was present in the environment he operated in. It is not primarily about violence, though violence was a tool he understood and used. It is about a specific kind of institutional intelligence, an understanding of how organizations that hold formal power actually operate when the distance between their stated objectives and their private constraints becomes large enough to be exploited. Bumpy Johnson understood that the federal government, like every large institution, had interests that did not always align with its stated mission. Prosecutors had career concerns. Officials had political vulnerabilities. The machinery of federal law enforcement was not a unified instrument directed by a single coherent will. It was a set of people with individual positions, individual exposures, and individual fears. Bumpy treated it as such. He did not fight the institution. He identified the people inside it whose fears could be addressed, and addressed them. This is what made him more durable than operators who were larger, wealthier, or more organizationally sophisticated. The Genovese family had more resources than Bumpy Johnson. They had broader reach. They had established relationships with law enforcement and political figures across multiple cities. They were dismantled over time by federal prosecution. Bumpy Johnson, operating in a single neighborhood in Upper Manhattan, outlasted federal attention that was directed at him with serious intent across multiple administrations. He died on July 7, 1968, at a restaurant on 125th Street in Harlem, at a table in the company of people he had known for years, in tea. He neighborhood where he had been born into the weight of American history and had refused across a long and complicated life to be moved from it. He was 62 years old. He had never left Harlem on terms set by anyone other than himself. The Attorney General, who called his lawyer at 2 in the morning and gave him a Friday deadline, left Washington 3 weeks after Bumpy sent an envelope. He did not return to public life in any significant way. History recorded his departure as a personal decision. Harlem recorded it as something else. Washington, through every administration that directed federal attention at Harlem's street economy, never fully absorbed the lesson that Bumpy Johnson's career represented. The lesson was not that the law was powerless. It was that power exercised outside the law's actual framework, through phone calls at 2 in the morning, through the informal coercion of citizens who had not yet been charged with anything, was not stronger than the law's framework. It was weaker because it created exposures that the law's framework was designed to prevent. And in the hands of a man who understood exposure, those weaknesses were sufficient. Bumpy Johnson never wrote a memoir. He gave no lengthy interviews in which he described his methods or his philosophy. The historical record of his life is assembled from court documents, investigative files, the accounts of people who knew him, and the oral tradition of a neighborhood that understood him better than any official document could. The story of the envelope, of a sealed package sent without a note, without a written demand, without a single word that could be read in a courtroom, is consistent with everything that record suggests about how he operated. He communicated in the language of demonstrated knowledge. He did not threaten, he showed. He let the person receiving the communication doctor their own conclusions about what the demonstration meant. Those conclusions, in the case of the Attorney General of the United States, were apparently sufficient. Power in the conventional sense is the capacity to compel. The federal government had that capacity in abundance. It had statutes, prosecutors, investigators, grand juries, and the full weight of the American legal apparatus. Against one man in Harlem, that capacity was insufficient, not because he was beyond the law's reach, but because the people directing the law's reach had private vulnerabilities that the law was not designed to protect them from. Bumpy Johnson understood that the distance between a man's public position and his private fears was always navigable if you had the patience to map it. He had spent a lifetime developing that patience. The envelope was the product of it. He stayed in Harlem, the Attorney General went home. The lesson passed into the oral history of a neighborhood that had always understood, from long experience, that official power and actual power were not the same thing, and that the distance between them, in the right hands, was enough to live in.